Hi everyone. In this lecture we're going to finish up our discussion of assumption of risk, and specifically the implied form of assumption of risk that deals with inherently risky activities. When we're done with that, we'll move on to sovereign immunity. I've just presented a fuller flow chart that indicates how you would handle contributory negligence, comparative fault, and now assumption of risk. But when we finish with sovereign immunity, you can add that defense onto this list as well. All right, so under implied assumption of risk, we saw that ordinarily a defendant would have to prove that a plaintiff knew the specific risk that he or she was facing and voluntarily chose to encounter it. But there are some special circumstances where courts will have a more bright line rule, and this does apply to inherently dangerous activities. So someone who participates in an inherently dangerous sport or recreational activity, or even perhaps an occupation, which we'll see a little bit later on, can be assumed to have accepted the risks that are inherent in that particular activity or sport or occupation. Some courts will simply apply the assumption of risk doctrine and grant the defendant the defense and throw the plaintiff's case out. Some courts, though, will treat this as a no-duty principle. The idea is that either the host of the sport or activity or the other participants in that sport or activity have essentially been released of responsibility by the plaintiff, and so those parties don't owe the plaintiff any duty of care. And so courts might throw these cases out on the ground that the plaintiff can't satisfy the first element of a negligence cause of action. Now, there's a couple of reasons for this bright line rule. One is, and I think they're related, is to encourage participation in recreational activities, but also, and I think this is the connective part, that in doing that, we're not only helping to improve people's physical and mental health, but we're also encouraging them to engage in social interaction, and all of that is viewed as socially desirable. Now, it's not always clear whether or when a risk is inherent in a sport or activity, and so courts have identified a number of factors that can be used to make that determination. One is just how obvious or commonly known the risk is. So if you were to take tackle football, an obvious, commonly known risk is that one party is going to throw his or her body toward another and try to knock that person to the ground. A second factor is just how integral or necessary or desirable the risk is to the sport or activity. So again, going back to tackle football, because tackling is an essential part of the sport, and essentially you would change the sport if you were to eliminate tackling. You could say it's an inherent part of that sport, which is integral or necessary to its utility. The final factor is whether or not the risk is avoidable or unavoidable. And again, with regard to tackle football, the risk associated with tackling, that is one body being thrown against another for the purpose of knocking the other to the ground, is going to carry the risk of bumps and bruises and broken bones and possibly concussions. And so when you look at all of those factors, you begin to realize that tackling and the kinds of injuries that I just described that are associated with tackling are inherent risks of the sport of football. Now, we had a couple of cases to help tease out what may or may not be inherently risky. And the Murphy versus Steeplechase case, another Cardozo case, it's a very famous one in which a guy gets on an amusement park ride, which was a conveyor belt, knowing that the conveyor belt would be moving. And as he got on and the belt was moving, he lost his balance and ultimately wound up getting hurt. And he sues the amusement park here for his injuries. Well, Cardozo was not very sympathetic, and he essentially espouses this inherent risk doctrine. The moving belt is a desirable part of the activity, and the risk of falling is obvious and unavoidable. In fact, the very reason why people were getting on the belt was to have the fun of being jostled around to and fro and possibly even falling. And so the risk that the plaintiff was complaining about was the very thing that gave the activity its utility. And so in this case, the plaintiff had encountered that inherent risk, the instability of the belt. He got injured as a result of that risk, but he had assumed that risk because it was just a necessary integral part of that activity. And so he was barred from recovery. In the second case, this is the Clover versus Snowbird ski resort case. Here we had a ski slope with an intermediate slope for average skiers that had a slope attached to it that would allow folks to make special jumps. And our defendant here, co-defendant, was an employee of the ski resort, and even though he was supposed to avoid that ski jump area, decided as he was going to work to go down and jump off that ski slope. And ultimately, as he did, he couldn't see below, and he wound up striking our plaintiff, who was an average skier who had no idea that there was even a ski jump anywhere near. So she was complaining that the negligence of the ski resort caused her injury, and the negligence of the employee also contributed to that injury as well. The question is whether or not getting struck by another skier is an inherent part of the sport of skiing. So when you look at this, you could say, well, yes, it is true that when you go on a ski slope, you might expect to be struck by other skiers, and the statute in this case actually, in a list of risks that are inherent in the sport, does indicate that people can expect that they might be struck by other skiers. But the negligence here wasn't just as a result of someone not skiing correctly or the resort allowing people to ski in a somewhat negligent fashion. The negligence here really revolved around the design of a ski jump, an unexpected ski jump that was unknown to other skiers and even could create a blind spot for the person who was doing the jump. I don't know about you, I'm not much of a skier, but I would not expect to have a ski jump on an intermediate slope and to have people flinging themselves into the air and then landing upon me as I'm skiing below. And the court, I think, wound up agreeing with that here as well, that even though it's foreseeable that people will run into each other, it's not foreseeable, it's not inherent in the sport of skiing to have jumps in an intermediate slope and have an enormous blind spot that could cause dramatic injuries to the plaintiff here. And so this risk was not inherent in the sport. This was a secondary risk that had been created and added into the ski slope by the resort operator and also by the guy that was skiing down the slope himself. Because the question of what is or is not inherent is a little bit tricky, I thought I would give you a few video illustrations, and I'll let you watch these videos and figure it out, and I'll just very briefly describe what's going on here. In this first scenario, this involves participants in the sport of Little League Baseball, and it involves the use of a metal or aluminum bat, and a ball struck by the bat winds up hitting one of the players who sustains really severe injuries. So do check out that video. There was a lawsuit against not only the Little League, but also against the bat manufacturer, and the contention was that the negligence of the league and of the bat manufacturer is really what caused this injury, and it was based on the fact that the bat creates a velocity to a struck ball that's different from the inherent risk of a batted ball under normal circumstances. And by that I mean with a wooden bat, which is what is traditionally used in a baseball game. And so the question is whether or not now the risks of excessive speed from metal bats has become so commonly known and so well accepted that it's now an inherent risk of the sport, or is it a secondary risk that's been added to the sport by the leagues that are purchasing these bats and by the manufacturers that are making it? And so I'll leave that to you to decide. That's not an easy question. The second scenario involves a spectator at a NASCAR event, and so check out this video. There's actually a lot of these scenarios where a crash on the track winds up throwing debris into the stands, and then the spectators wind up getting injured by the debris. So when you watch this video, you see that this has happened at this particular track before. The question is whether or not there is an inherently dangerous aspect to even the spectator aspect of a NASCAR event. And most jurisdictions in baseball stadiums and hockey rinks and even here at NASCAR events have said yes, that not only do the people participating assume the inherent risks, but spectators also know that there are dangers that can be extended from the track or from the field or from the arena into the stands. So the question would simply be whether or not the person is struck in a way that you might expect, like having a piece of metal from the car or maybe a tire leave the roadway and strike somebody, or it doesn't happen in some unforeseeable, unexpected, or bizarre way. But generally speaking, spectators do assume the expected, normal, customary risks associated with watching their particular sport. Finally, certain occupations can be inherently dangerous, and this is oftentimes called the firefighter rule, but it actually applies to any occupation, perhaps like being a law enforcement officer, that has an inherent danger. So check out this video. These were some firefighters who got injured as a result of attending a fire and fighting a fire that had been started because of the negligence of a homeowner in failing to put out a flame in a grill. Generally speaking, these folks, the folks that work in these highly dangerous occupations, they get paid a kind of hazard fee for assuming those risks, and so tort law doesn't go out of its way to protect them. They are expected to assume the inherent risks of their jobs, and for firefighters, one of the inherent risks is that you might have to put out a fire that has been negligently started by somebody else. So there are some limits to these doctrines, but for the most part, these general rules will hold true. All right, so with that, we'll now turn from our affirmative defenses of contributory negligence, comparative fault, and assumption of risk to sovereign immunity. And I wanted to start by having you consider the similarities but also the differences between the defenses we've already covered and the concept of an immunity. So in a defense like contributory negligence, comparative fault, and assumption of risk, the defendant remains susceptible to liability, but the defense winds up reducing or in some cases possibly eliminating the plaintiff's recovery. This is important because it means that the plaintiff has the right to file the lawsuit, and it's incumbent on the defendant to find some escape route by convincing the trial court to throw the case out. Oftentimes, though, courts, because these are highly factual scenarios, will give these questions to the jury, and so the entire case may be litigated right till the very end when ultimately the jury decides whether or not the defense has been sustained and if the plaintiff can recover something or nothing at all. An immunity is a little bit different. An immunity basically says that the defendant is not really even susceptible to legal action. And that's based on the defendant's legal status, that there's something about the defendant that protects them against the lawsuit. And because that's true, because essentially the whole question is whether or not the plaintiff has the right to even sue the party, this is a question of law for the court and usually will be decided on a motion that the judge alone will decide. And that is going to be the nature of sovereign immunity, which we'll turn to next. All right, the sovereign immunity doctrine is a very old doctrine that dates all the way back to the medieval period in tort law, and it really just meant that the king can do no wrong. Now, this was inspired by the divine right of kings theory that because the king was divinely inspired, there's no way that the king could make a mistake. There was also, though, I think always a political underpinning to this, that if the king or the governor or whoever the governing body was constantly subject to lawsuits by citizens, that you could never really get anything done, and the authority of that governor would be dramatically undermined. So that political part, I think, was transferred on from England to America, where we assumed the sovereign immunity doctrine and applied it to our public agents and agencies. And the idea here is that when a public agent or agency winds up causing harm to a citizen, that we're going to immunize that party or that institution against civil liability. Now, the procedure here is very much like a defense, but there's a little nuance which I've hinted at before, and I'll just reaffirm here. So like a defense, the defendant must plead and prove the elements for sovereign immunity, but this is almost always going to be litigated in a pretrial motion, oftentimes in a motion to dismiss or possibly in a motion for summary judgment. Because this is a question of law, the court has to decide it. And if the court does decide that the defendant has sovereign immunity, it means that the lawsuit can't even proceed because the defendant isn't susceptible to a legal action, and so the case would have to be dismissed. Conversely, if the court finds that there is no immunity, then the government agency or agent would be amenable to the lawsuit, and therefore the case could continue. There is a question about what we mean by a public agency in a very broad way. It's an entity that's created and operated by the government or some governmental subdivision, and it's really just designed to provide some kind of public service. This can exist at the federal level with the federal government. It could include the state government or any variety of local agencies that provide government services. So you might think of a variety of examples here. So at the federal level, you might think of the Food and Drug Administration, right? That's a federal agency, or the Department of Homeland Security. But you might think of state or local police, or a fire department, or even a public school, right? Or a publicly operated prison. Any one of those could be viewed as a public agency and might claim sovereign immunity. Now, there's a variety of public policy rationales that have been given, and maybe the most important is this idea of checks and balances, or a balance of power. The idea is that courts don't want to tell other branches of government how to do their jobs, that the balance of power suggests that each branch has their own sovereignty, and the judicial branch shouldn't be telling the legislature how to perform its functions, and shouldn't be telling executive officers how to do their jobs either. That typically it's better left to the legislature to allocate these responsibilities rather than judges going around and forcing people to change what they do. Another reason, which is related to this, is courts don't feel like they have the expertise to be able to know how other branches of government are supposed to do their jobs. For example, a court might feel very uncomfortable telling a police commissioner how to allocate police resources to stop violence in the inner city. So that's a job that's better left to the expert agency than being allocated either to a court, or possibly, perhaps worse, to 12 people drawn from the public and now sitting on a jury. Another classic tort argument here invites the opening of the floodgates of litigation. Because government provides so many services, if one or more of those services goes wrong, then it's quite possible that a citizen might be inclined to file a lawsuit. And if you multiply that by all the people who are dissatisfied with government service, then you've got yourself a whole flood of litigation. And the final one is that there's just a limited amount of resources that any government has, and those resources are determined by taxes. And so anytime the tort system might say to another branch of government that you need to spend more money in order to create a safer environment, or to provide greater safety to people in a particular aspect of their lives, you are in essence saying you either must reallocate the resources you already have, or you're going to have to raise taxes. Either way, that's a very controversial notion and one that the courts would rather avoid. All right, so let's explore sovereign immunity at the federal and the state and local level, beginning first with the federal government sovereign immunity. Well, that common law immunity had existed up until about the middle part of the 20th century when Congress decided to abolish the federal government sovereign immunity with something called the Federal Tort Claims Act, or the FTCA. Congress thought that the doctrine had gotten anachronistic and possibly believed that it was unfair to citizens not to have recourse, and so they got rid of the common law doctrine. Now, within the FTCA, there are a number of exceptions that still allow the government to enjoy immunity, and frankly, these exceptions are numerous and expansive enough that in some ways, the exceptions almost swallow the rule. So here are the areas where the federal government still enjoys sovereign immunity, even under the FTCA. One is for intentional torts, that you can't sue the federal government for the intentional torts of its agents. You also can't hold the federal government strictly liable. You'd only be able to sue them for their negligence. And you can't get punitive damages to punish the government for the misbehavior of its actors. And perhaps most importantly, you can't hold the federal government responsible when its agents are engaged in discretionary functions. Now, we're going to talk a lot more about this particular exception. It's been used by courts in a variety of contexts, and its exact meaning is not clear. And so if you're a little bit frustrated by the concept, don't worry. The courts themselves are having difficulty trying to determine exactly what it means. Now, at the state and local level, we had the Campbell case versus Indiana, and here they were trying to decide what, if anything, survives in the sovereign immunity doctrine at the state or possibly the county level. Now, the court doesn't get into this very much, but many states, either by adjustments to their constitution or by statute, have essentially embraced the Federal Tort Claims Act, and they've adopted some version of that act as their own. They actually model their state Tort Claims Act after the federal one. That means that they've eliminated sovereign immunity for the state government, but they do maintain a list of exceptions, and one of the key exceptions is going to be that discretionary function exception. So that kind of reinforces just how important that particular doctrine is going to be. Now, where there isn't a constitutional provision or a state statutory provision that immunizes the state government, the question is what happens to common law sovereign immunity, and this is what was being addressed in the Campbell case. And so here courts have made a distinction between proprietary state functions and governmental state functions in the hopes of trying to somewhat limit the government's responsibility. Now, states generally say that if their actors are engaged in core governmental functions, that is, that they're promoting the historic police powers of protecting the health, welfare, and safety of the citizens, then the government shouldn't be sued because it would be too difficult for them to carry out those functions. But if the government is just providing a kind of proprietary function, oftentimes making money off of that service, and it's not really a core government service, then it's no problem in holding the state responsible for the negligence of its employees. One of the illustrations that comes out of the Campbell case was a county that had operated a skating rink and charged admission to its patrons, and one of those patrons wound up getting hurt. There, the court said that that was just a proprietary function. It's not providing a critical government service. It's really kind of a satellite government function and one where they're making money, and so it seems okay to hold the county responsible for its negligence. Now, in this particular case, the court doesn't like the elusive distinction between proprietary and government functions, and so it decides to abolish sovereign immunity, believing that there really isn't a risk of floodgates and that it ultimately would be fairer to its citizens to allow them some opportunity to sue the state when it engages in negligent conduct. All right, so let's take a closer look at the discretionary function exception as it applies through the Federal Tort Claims Act, and we'll use the Sestanaro versus U.S. case to really get a better handle on what's going on here. So we have a family that goes to the American Virgin Islands for a vacation, and they park their car in what they believe to be a National Park Service parking lot. And when they come back to their car, the husband is shot in an attempted robbery. And they wind up suing the U.S. government and the Park Service, complaining that there was inadequate lighting in this alleged parking lot. So the government is declaring here that there is a discretionary function involved, and therefore they're protected by sovereign immunity. And so the court has to decide, well, what does discretionary function mean? Unfortunately, the statute itself provides no definition for the term, and so courts have had to try to make it up as they go. Now, the essence of this is basically this, that there's a policy decision that involves the exercise of discretion or judgment by a government actor. And so you can see within this basic concept two notions, and both of these notions have to exist for the exception and the immunity to apply. So the first part of this analysis is whether or not, in fact, the Agents Act was discretionary, or conversely, if it was specifically prescribed by the government. Now, if it's prescribed by the government, that is, if the statute tells the actor how they're supposed to behave, the exact manner in which they're supposed to engage in a particular government function, then the court would actually be doing the government a favor by using a tort action to ensure that that statutory scheme is followed, that it wouldn't be inconsistent with another branch of government. It would actually be honoring the spirit of the other branch of government, in this case the legislature, by enforcing their prescriptive statute. So if it's prescriptive, then the discretionary function exception will not apply and a tort action could be brought. Conversely, if there's no prescription, that is, if the statute doesn't tell the actor how to behave, that means that the actor does have some discretion in how to do the particular job in question. So here, because there's a judgment call involved, the court would actually be second guessing what in essence could be a very complicated cost-benefit analysis performed by an actor that is basically getting his or her authority from another branch of government. There, the court does risk stepping on the toes of a co-equal governmental branch, and so the discretionary part of it leans toward the adoption of the exception that brings back the immunity. But remember, that's just the first step. There's got to be discretion, but even if there is, the second question is whether or not the actor's behavior was promoting the policy or purposes of the agency and perhaps the statute itself. So if it doesn't appear that there is any particular policy basis for the action, that it was just simply a ministerial act that was being carried out by the actor without a whole lot of thought involved, there it actually does make sense to hold the agency responsible, because again, you're not really second guessing any decision making. You're really just correcting what looks to be non-deliberative, almost careless behavior. On the other hand, if there is a kind of policy analysis or a policy basis for the exercise of the agent's discretion, then the government or the judiciary really would be stepping on the toes of the other branch of government, whether it's executive or legislative, by telling that other party how they're supposed to do their jobs. So if there is a policy basis for the exercise of that judgment, then the discretionary function exception would apply and the government would enjoy immunity. Now, how does all of that play out here? So the court does go through this two-step analysis, and in the first step, when it's asking whether or not there was some prescription for the Park Service to maintain the lot the way that it did or not, it looked like there was a 1985 agreement that gave the National Park Service discretion as to whether or how it was going to operate this lot. And there's actually language within the agreement that says that it really depends on how much funds they have available to be able to maintain it. And so the court acknowledges that it looks like there was discretion given to the Park Service about the operation of this particular space, which arguably was being used by people as a parking lot. But remember, that's just the first step of the analysis. The court then goes on and determines whether or not the decision making about the lot, and specifically about providing lights or warnings, was a policy-based decision or whether it was really just a kind of ministerial act. And here the court winds up saying that this doesn't really look like it's policy-based. The original decision to maintain that property, or possibly even to erect the lights, that might have been based on some policy about maintaining the historic appearance of the island and that particular space within it. But exactly how that lot was maintained, where the lights would be used, how often perhaps they would be fixed, perhaps if there would be any additional warnings that accompany the lights, all of those kinds of considerations really look to be just kind of ordinary decisions about property ownership. And so here the court says that that's not really policy-based. In fact, in many ways, it looks like there wasn't very much deliberation or thought going into how that particular piece of property was being maintained by the government. And so the court said because there really wasn't any policy decision in about how that parking lot, or at least that parking space, would be maintained, that it would be okay for the government to be sued because there really wasn't a discretionary function involved. Of course, the flip side to that is if you really buy the National Park Service's argument that maybe you could say that not having more lights and not doing anything more to promote this as a parking space was really designed to keep it as kind of a historic structure and to keep the grounds as pristine as possible. And so maybe some higher up, some administrator actually had made a decision about having a hands-off approach to that particular lot in order to maintain its pristine character. Court didn't really buy that. I think the court really felt like the government here had just basically dropped the ball. They knew a lot of bad things were happening there. They basically didn't care or didn't have the resources to do anything about it. And so they just simply let it unfold as a very dangerous area that the government was controlling. And ultimately, that was good enough for the court here to say, no sovereign immunity. This tort case could continue and hold the government responsible for its negligence. To give you a little bit more experience dealing with the discretionary function exception, I'm going to go over a few of the problems on page 512 of your casebook. The first one deals with, this is 3A, deals with a federal regulation that says no VA doctor can work more than 20 hours straight. The local VA administrator, though, allows a reliable doctor to work 23 hours straight, but ultimately he commits an act of negligence that kills a patient. Question is whether or not this looks like a case involving some discretion and the discretionary function exception would apply, or if this is the kind of case where you'd hold the government responsible. Well, here it doesn't look like there really was any discretion. This is a case where the federal regulation specifically said that you can't work more than 20 hours. That's a prescription because there was really no latitude left under that regulation. It makes sense to say this is not discretionary, and the court can therefore enforce that regulation and the VA administrator's violation of it by allowing the case to go forward. So no discretionary function, so the cause of action for torts would be allowed to continue. In the second one, you have the Bureau of Prisons that requires regular inspections of gym equipment. The warden decides that the staff resources at the prison require him to limit the inspections to about every 3 months, but the prisoner gets hurt using a lat bar between inspections. The question here is, again, was this a discretionary thing so that the discretionary function exception should apply, or is it more prescriptive and non-policy based? Well, here it looks like kind of a classic case of discretion. There's nothing that specifically says how often the inspections were to occur. That discretion was given to the warden, and his decision to inspect every 3 months seems to be based on a policy choice given the limited staff resources. So that was a cost-benefit analysis by him. So it was discretionary, and it was based on a policy trade-off of safety versus financial concerns. So this would be an example of the application of the discretionary function exception, which would bar the plaintiff's recovery. The final one is a postal worker is in a hurry and he speeds through a school zone and it hits a child. So the question again is there a discretionary function exception here? Well, clearly there is some discretion in how you drive as a postal worker, but there's no policy whatsoever in just simply speeding through a school zone. That is, he's not making a calculation of the costs and benefits to the citizenry or to the postal service. He's really just, without thinking, essentially trying to get through his daily delivery chores as quickly as possible. So because this wasn't a policy-oriented choice to drive fast through the school zone, the court would have no problem saying this is not a true discretionary function. This is more of a really negligent or careless ministerial act, and therefore the discretionary function exception would not apply, and this case would go forward. So these are just some illustrations. As I indicated, oftentimes pretty much every case can be argued because the rule itself is so open-ended. So get to know the policy arguments, and once you do, you'll have a really good shot at making the best possible case for either the plaintiff side or the defense side involving sovereign immunity.